We're live.
All right, welcome back to the House Judiciary Committee. This Thursday afternoon, April 9th, we're going to now turn our attention to S209, an act relating to prohibiting civil arrest in sensitive locations. And we're going to, I think, three witnesses, if they all show up. We're going to start with Julio Thompson from the Attorney General's office. Go blue. Okay, I had to say that.
No, to the victors. Let's do a round of that.
Thank you for being here.
I don't know.
Oh, we thought.
That's why I asked. I didn't know who that
Maybe Karen Barbers.
Yeah, right here.
Good afternoon, and thank you for inviting me. My name, for the record, is Julio Thompson. I'm an Assistant Attorney General and Co-Director of the Civil Rights Unit. Part of our responsibility in the Civil Rights Unit relates to constitutional issues, including federalism issues, that is, legal issues presented between when either state or federal law is being applied and one has a direct or indirect impact on the other. So I'm here to talk about S209. The committee invited me here to speak. I didn't receive a specific request to address it, so I'll leave it to, if there's general direction from a chair of the committee, and then I'll be happy to move in that direction.
Yeah, it's just those issues you just mentioned. I mean, how does this work as far as, should we have big concerns? We have good arguments if this is challenged as being unconstitutional because of the supremacy clause. I mean, that's the main thing that I thought that we would like to hear from.
Okay. That is something I'm prepared to speak about today. So S209, again, for the record, for those who are listening out there, is the proposed act to prohibit civil arrest in so-called sensitive locations, which amend the existing statute regarding civil arrests in courthouses and extend to areas such as schools, healthcare facilities, places of worship, and a variety of other locations that are on property that are related to the state of Vermont or to areas within the state of Vermont's legal authority. It's often in constitutional law called police powers, even though that's not confined to law enforcement, would include things like health and welfare regulation within the state borders. Looking at the bill and also having the benefit of looking at some, but not all, the testimony, I think there's good reason to believe in existing law that states do have the authority to regulate locations relating to civil arrests without violating the U.S. Supremacy Clause. A good deal of S209 relates to areas that are either owned or operated by the state. Those aspects of the law tend to be the easiest, and that doesn't mean easy, but the easiest to defend, because there's well-settled case law that state and local governments, as a proprietor of its own property, can regulate those who access that property and the conditions and the activities that are on that property. So I think schools, state municipal buildings in Vermont, municipalities are a subdivision of the state. So I think well within the scope of that authority. This is not an area where it appears there are particularly strong arguments for federal preemption. Preemption, remember, is a conflict between state and federal law or actions where Congress has either regulated an area and state action would conflict with federal law. And under the Supremacy Clause in Article 6 of the Constitution, federal law would govern. This is not an area where Congress has regulated, and there's no clear mandate, at least in our view, that Congress has precluded states from governing access as to locations for where it wants to regulate where certain activity may take place, including immigration enforcement. There is somewhat not widely known. There is a federal law that Congress enacted decades ago that specifically addresses location for immigration arrests or when federal agents may enter lands, and that's specifically addressed to land located very near the international border, where Congress authorized officers to go onto open lands but not into dwellings. But there's nothing there indicating that Congress precluded any other sort of, precluded states or municipalities to kind of govern activities on their own form. And as I think a couple of years ago, more than a few years ago now, maybe in 2022, when this committee considered the courthouse specific predecessor to this bill, there had long been a common law privilege for courthouses, and there was no real indication that Congress intended in its immigration laws to, supersede that common law privilege. So the area of preemption, I think, it is just an area where, again, it has to do with Congress. You have to have a law for preemption or a statement that it's basically off limits for state and local governments. We might see that in areas, for example, dealing with private sector labor relations under laws like the National Labor Relations Act or the Labor Management Relations Act, where it's very clear that Congress wanted to govern the area of private sector collective bargaining so as to have a uniform system. And there are similar congressional pronouncements in areas like copyright and trademark law, to name just a couple of examples. And we don't have that really here, except with the extent that only the federal government is authorized to make arrests for civil arrests with respect to immigration. That's exclusively a federal function. There's another type of conflict that can arise where constitutional issues presented, even where Congress hasn't spoken. It's got a terrible clunky lawyer created or judge created name called intergovernmental immunity. That's a common law, which means judge-made law doctrine, where states are generally prohibited from enacting laws that either directly regulate federal officers or they discriminate against them. And here for 209, we can take the second component first because it's the easiest. On its face, S209 is not discriminatory. It applies to civil arrests, which state and local officers are able to carry out, as well as federal immigration officials. There may be other federal civil arrest authorities as well, but it's not targeted exclusively towards ICE. And that's really the test that the court looks at is not, what people were thinking, that legislative intent is often difficult to divine, but in terms of what is the effect of the law, does it target only federal activity? And S209 does not. I saw a hand up in my.
Yeah. Before you, Tom.
I've had a couple I've gone on.
Sure.
So to rewind a little bit, so you talked about private or government areas. What about public areas traveling to and from?
So public areas of. So are you referring to language in the bill about traveling to and from? So that has to do, I think, with page 1, subsection C, that talks about subject to civil arrest while traveling to, entering, remaining at, or returning from, and then it identifies the various properties. There isn't a lot of law in this area, and different states have taken a different approach. Illinois has something called CASPA, which is the Court Access, Safety, and Protection Act, which the statute creates a 1,000-foot buffer zone that surrounds the protected locations. Principally, there it's courthouses. That case is currently under legal challenge, and there hasn't been any. Even the first, kind of motions filed in the case haven't been fully briefed. Last year, California, New York state, which has a 2020 law relating to courthouses called the Protecting Our Courthouses Act, or POCA, uses essentially the same language, going to, remaining at, returning from. the place of a court proceeding. The United States sued in that case and saying that it interfered with federal authorities. The district court ruled against the government. The court, at least in that case, the Justice Department in that case didn't focus on the travel language, but just objected to the law in general. And the court said that this is something that's within the state's sovereign authority. And so that case is currently on appeal. The decision came out last year, last year from the Federal District Court for the Northern District of New York. That was when the United States government challenges a law, they usually challenge the entire law and say the whole thing is invalid, which is called a facial challenge. And the standard for that is that there's no application of this law that could be constitutional. And that's what the US government challenged. I think in the future in New York, and if S209 passes, we might anticipate that there would be individual cases where a private lawsuit is filed or the attorney general's office files a court action where the question of the application of the law regarded to a specific set of facts would be subject to argument by the state of Vermont or by the federal government. So the idea, for example, that someone traveling from Squantum to a court hearing in Brattleboro and they're intercepted by immigration authorities while they're stopping at a bathroom break on a rest stop or at a gas station along the way to refuel. If they're apprehended then, I think that would be something for the courts to address. The balance of interest really would be the effect of the law on federal operations versus, which I think would largely be de minimis. Those would be relatively rare and infrequent circumstances, one could imagine, versus the state's interest in having people appear for court hearings. So I can't say in advance what a court would do on that, but those would be the sorts of cases I think where they could come up. I do think if I'm not sure the Attorney General would bring such an action, but imagine, for example, that someone has a court hearing that's in Delaware and is arrested at Boston Logan Airport. It seems unlikely that a court would find that Vermont state law extends beyond its state's borders. So I think that when a court interprets a statute, it interprets it in a way that's constitutional. It assumes that it's going to be constitutional. So it's conceivable we might have in the future, if this bill is passed with that language, that we may have some court, that will apply more fact-specific determinations, which is not uncommon for statutes. I work in civil rights unit when we deal with things like the Americans with Disabilities Act, where there's requirements to provide reasonable accommodation for disability. And people say, well, what does that mean? And it's a very fact-specific inquiry. I would expect that it would be in the individual case rather than a lawsuit attacking the whole statute. The government may be in a position to try to make its case that in that case, the interests of the state in court appearances are not nearly at issue. And that would certainly be in a case, for example, if someone decides to take an errand, run an errand, which in the laws tends to be known as a frolic and detour. I think it's the phrases that the courts use where someone abandons their principal purpose in travel to take some other direction. So I think that would be something that courts would probably look at from a state by state basis. But, in terms of the language on its own, I don't think it puts the entire statute in jeopardy or the bill.
Can you have any opinion on the statute as regards to Vermont law enforcement not making civil arrests in the state of Vermont?
Well, I think the statute prohibits civil arrests for everyone, so it would include state and local law
Well,
enforcement.
Vermont law enforcement doesn't make civil arrests.
Well, I think there has been historically
Without a
authority.
warrant?
I'm sorry?
Without a warrant?
Well, this isn't confined to warrantless arrests. It's just speaking of civil arrests. So there can be.
Just to be clear, there is exceptions that it doesn't apply if the arrest is pursuant to a warrant or court order. So,
so I am talking about, I'm not really that familiar with, what sheriffs, I mean, historically sheriffs have been authorized to execute such warrants and those are court issued. I'm not aware of a civil arrest authority, that's akin or analogous to say a probable cause, misdemeanor.
We're regulating
Yeah.
one and not the other though. I mean, because we don't do that. It's not in practice law.
Yeah, but that's a very important point. And the test for whether something discriminates against the federal government is whether the federal government is being treated worse than similarly situated state actors. And so you have to have what the courts call a comparator. You have to show someone who is in a similar situation to the federal officers and are they treated better. And so if state officers don't have that authority, they can't necessarily be treated better if it only applies to one type of authority. That was part of the reasoning that was used recently in a district court case in the Central District of California recently on California's no masking law, where the court in that case was looking at whether state law enforcement officers were similarly situated to federal officers and found that that they did have roughly parallel authority to conduct arrests and detentions consistent with the law. So the fact that the question would be, is there an activity that Vermont officers could do that the federal authorities can't do? And the answer here, I think, would be no, that they wouldn't be able to make a warrantless civil arrest, and neither would the federal officers. And so there wouldn't be a basis for discrimination.
Karen, you good, Tom? Sorry.
If you just answered that, because it's not that Vermont law enforcement are specifically barred from doing civil arrest, correct?
It's not a practice.
It's not a current practice, but
Yeah.
practice can change at any moment.
That's right.
And this makes it specifically clear that this is not allowed.
That's
But
right.
that's the difference that I see.
So it's preemptive. Doesn't exist. So.
Well, I think that's right. I mean, typically and there have been different legal tools that have been used to prohibit civil arrest. Sometimes it's done by executive order in some states. In some states, it's been done by legislation. And in each of those cases, they've all consistently related it to civil arrests versus criminal arrests. And I think, in reading those laws, and I've read, I think, most of them that have been enacted, not all the bills, but most of the laws and executive orders. And the balance that has been struck is that public safety. Also, an arrest warrant issued by a neutral judge, basically on a higher standard than we would expect for a civil arrest. And so that's kind of the balance that's been struck. I think with the passage of 209, there wouldn't be a mechanism to permit prohibited civil arrest without the legislature going back and basically rescinding that. I think it would. I haven't researched the executive order issues here, but I think it would be challenging, for example, for there to be an executive order that would dictate something contrary to state law. I think the trickier issue, rather than non-discrimination, is whether this directly regulates federal authorities. And the general rule is that states can't direct the functions or control the activities of federal officers. And there's a flip side to that cord. They're generally preserved under the 10th Amendment for state officers to do their business without direction by the federal authorities in terms of how they carry out their jobs. There's less case law on that. This is when you have a law of general application. What the courts look at is to see whether it's something that how much it actually affects federal officer versus incidentally affects them. For example, federal legal authorities have to follow state traffic laws, and those they would be subject not only to civil action, but criminal action for state criminal justice laws. And that's not because they're being controlled directly. That's the test, direct control. But rather, those are incidental effects of being in the state of Vermont, just like everyone else. So Supreme Court in a case back in the 1920s said, things like traffic laws, they apply to everybody, and that's a permissible area. And so really here we're talking about, so the question will be, if there is a legal challenge, to what extent does this really affect immigration activities? And I think there are strong arguments that the impact is de minimis. Dating back to the Clinton administration, there have been substantial restrictions on immigration authorities' ability to carry out civil enforcement activity, not just for courthouses, but for other places, including places of worship, schools. I think there was a Obama administration directive for Homeland Security that talked in generally about places where children and their families may congregate, which is pretty open-ended. So what you're really talking about is here isn't like a federal statute or a right that's in federal law or regulation. What you're talking about is an activity that historically has been discretionary for the federal executive branch. And so the United States would have to make the argument that this law would substantially affect those operations where it's clear that, Vermont, I don't know what the number is exactly, but I think it's close to 1,500 square miles. That's kind of flat, traversable land. The rest is mountains and water. And you're really talking about less than 1 or 2% of the landmass that would be affected on a generous estimate. So you've got better than, roughly 99% of the state where the law doesn't touch federal law enforcement activity, doesn't address the ability to make arrests at, other places where people might be found in public. It's just either at or going to or from these places, which really relate to state sovereign interests, which is like health and welfare, law enforcement, schools, education, and services available to people either related to the education, health, or criminal justice system. So I think there are good arguments to be made there. It doesn't mean that the courts will necessarily agree. There isn't a lot of case law on that, but in terms of, in the context of courthouses, we do have the most recent decision by the federal court in New York. And, we expect to see other decisions. Similarly, it'll just be a question, I think, as to how far that authority extends. As I started out with, when you're talking about state-controlled property or property where state mandated or supported programs are, I think that tends to be the stronger end of the spectrum, and we'll see how far the courts take it in the other direction. So those are my comments about that.
Any other questions for Julio? Don't see. Thank you. No, that's what I wanted you to cover, and I really appreciate your input on this. So thank you. We will then go to Beth St. James. It is delightful having you back. What did you hear last year, I think.
I think it was last biennium.
Well, bienniums go by so quick.
Impeachment.
Well, yeah, we did. Yes, we
Don't
did
get me
spend
too
lots of
excited.
quality time on impeachment. Coach, go ahead. I didn't see your hand till just now. There you go.
Just had a quick question, Martin, about we haven't seen as many of them as this often, but when they would customs would come down and at exit 1 and create a full stop, you had to stop, go through the lane, and usually the customs police and customs officers and the state police would be at that.
Julio,
that
if you could hold, just in case is this a question for Julio Thompson?
Probably more regarding Julio's comments.
Okay. All right. What's the question?
So the question is, in those situations where the Border Patrol would have a roadside stop in White River and all traffic would be stopped and have to go through that gauntlet, so to speak. And you know, are you a U.S. citizen? Blah blah blah. Are you a Vermont citizen? etc. And those were the general questions that were asked.
What's the question though?
No, it- is that a situation that would be affected by this, this new statute?
So I don't think we cover roadside stops. Oh, you mean if somebody's traveling and they get stopped?
No,
They're like traveling to the courthouse or something like that and they get stopped on one of those?
They set
yes,
up outbound and inbound check.
Right.
let's say, because we also have a courthouse, in White River, and let's say they're going down 91, from Quechee, to White River, and they get stopped in that stop on their way to the courthouse.
Yeah.
Yeah, so again, Julio Thompson, Attorney General's Office. It's possible that there could be an application there. I think the bill, which I put away in my backpack, I think talks about legal action where they knowingly are making the arrest to or from. So I think either an individual who's suing for violation of the law or the Attorney General's office, who we were going into court, we'd have some burden of proof, I think, to show that the officers making a civil arrest were aware of it. And that could be fact specific. Someone could say, look, I have a summons, I'm due in court in half an hour. So that's possible. It could happen case by case. There could be other instances where, deviating from, again, you're trying to look at hypothetical cases in the future. If, for example, in response to some enforcement prerogative, the federal government decides it's going to set up roadblocks down the road from every courthouse and school, off of school property, but in order to get to school, you're going to have to go through a traffic check. That would be something that I think that kind of practice would be something our office, if we saw that really did affect people's ability to go to school or to other sensitive locations, would be subject to a legal challenge for the court to sort out.
Okay, thank you. Because that's more of what could very well, just happen, because I'm thinking about that intersection and where it's been set up, over the last, 20, 30 years of going through and then running into one of those. And, now being on, this committee, you go, what the heck? What if? So thank you.
All right. Thank you, Julio. And thank you, Coach. And
So how's it different now than it was 20 or 30 years ago?
Well, the thing is they still set up the stop. So, you have to go through it. And, if unfortunately, you're, uh, you have migrant status of any range, for example, and
Isn't that
you're
what they were
going,
doing 20 or 30 years ago?
well, I'm not sure what they were looking for. If it was people, contraband, because they got a lot of good stuff during those times, So, it was just a general question, though.
all right. So thank you, Julio. And thank you for being here, Beth. Welcome back to the committee.
Thank you.
And we had questions for you, but I can't remember what the questions were. So maybe you just tell us about this.
Bethany James, Office of Legislative Counsel. I am your education policy
Oh.
attorney.
All Alrighty, heard about you a lot. You're finally
Here I
here.
am.
Woo. Is this like a nice break being here to talk?
Yes, it is actually. It's very lovely.
He still has its reason. What do they reuse call those?
Legacy hand.
Legacy hands.
I believe you have invited me to your committee to talk about the definitions in S209 related to educational institution. Is
Yeah.
that correct?
Yes.
Okay. So I'm going to stay as far away from the underlying policy of this bill as I can. Just because I don't want to step on my colleague's toes who has already shepherded this bill so far, and all I am here for is to talk about educational institutions. So in Title 16, we do not have a generalized definition for educational institution. We've got one-off types of definitions, and we don't even have a definition for the term school. Although your colleagues in Ways and Means are working on that right now. So in order to kind of rope everything into one term, what the Senate did was they created a new term of educational institution, which is not a new term, but it is a newly defined term. And then defined that term on page 4, line 16 of S209 as passed by the Senate. And what I did to come up with this definition was I basically combed through Title 16 and found everywhere where there was some sort of educational program that may have some sort of physical location where folks might be going, and referenced the Title 16 definition. So educational institution, for the purposes of this statute, right? This is as used in this subsection. Educational institution means a public school, which is a defined term in Title 16, and we refer to that statute. An independent school, which is a defined term in Title 16, we refer to that statute. The term independent school will sweep in both approved and recognized independent schools. Educational institution includes a regional career and technical education center, defined term in Title 16. An approved education program. Those are the types of approved education programs that I am most familiar with are teen parenting programs. Again, defined term in Title 16. Pre-qualified private pre-K providers. So pre-K that is pre-qualified under your pre-kindergarten statute. Most of those programs are in childcare centers. A post-secondary school, as that term is defined in Title 16, and that's going to be all your secondary education institutions, whether they are public or private. And education, this is a fun one because it is changing by the day. An educational program operated by a board of cooperative education services. 2 years ago, you all created BOCES in this state, which are just what their name suggests, boards of cooperative education services, and they can run their own educational programs. They are not a municipality. They are not a governance unit. They are a cooperative of supervisory unions who are supposed to share services. And the bill that your colleagues in education voted out just last week changes the name of this program to CSAWs. Instead of BOCES, we're working with CSAWs now. So just to be aware that this is change that is very much alive. Tutorial programs, I am, to be quite honest with you, not sure if they have brick and mortar locations or if tutorial programs are something that kids are doing at home on their computer, but to the extent that this that we wanted to sweep in tutorial programs, we have referred to tutorial programs and referenced them in their definition in Title 16. Adult education and secondary credential programs, again, referring to the program in Title 16. There are adult education and literacy providers located, and I think there's 4 of them that the state contracts with throughout the state. So there are brick and mortar places where folks are going for adult ed. So those are all of the different types of educational programs that I was able to think of in Title 16. And then all I did was reference their defined definitions to create that giant term of educational institution. And then we've also added here on page 5, line 13, educational institution also extends to the grounds operated by, activities sponsored by, transportation provided by, and programs related to educational institutions.
Angela.
I have one and a half questions. So I just wanted to make sure on page 5, lines 3 and 4, the pre-qualified private pre-kindergarten provider, do those, I know you mentioned those are basic in childcare centers, would that include in-home providers and church locations?
Ooh, I believe if you are pre-qualified, then yes. But let me pull up section 829.
Open, and I think I couldn't quite tell.
It is, I think that's fair. So pre-qualified private provider means a private provider of pre-kindergarten education that is qualified pursuant to subsection C. So nice circuitous definition there. Pre-qualification pursuant to rules jointly developed and overseen by the secretaries, yada, yada, yada. I believe, and then that subsection just lays out what you need to do to become pre-qualified. I think because there's no separate definition for a licensed home provider, I think they are swept in through the private provider definition, but I hear you on it is not as clear as it could be.
And church locations was a concern as well.
If it is a pre-qualified private provider, whether it is non-denominational or it doesn't matter.
Is there a list of pre-qualified providers?
I believe, yes, on DCF's website.
And then would you recommend at this time that we change Board of Cooperative Education Services to Cooperative Education Service Area?
Well, my answer is going to be reflective of the week I've had and the fact that it's 3:45. Depends on how confident you are that H955 is going to go anywhere.
And so that I couldn't recall, was that name change also in the miscellaneous bill?
It was, and then it was removed by an amendment from Ways and Means, and so it did not actually travel.
Okay.
It was voted out of education. Ways and Means removed it so that education could put it in 955, which is the big ed bill this year.
Okay.
Good. Any more questions?
Yeah, I mean, it's an answer.
Yeah, somehow we got sucked into that whole world of the other education stuff through this.
Long
that-
tentacles.
Yeah, that long tentacle of that. You couldn't escape that after all by coming in here.
My job security is so tight.
Excellent. Any other questions for Beth? I don't see any, so thank you very much. So
Okay.
for folks, I did reach out to BGS to see if they would want to weigh in state buildings, and they didn't show up or get back to us other than ask me what I wanted to hear. So I'm gonna work with Rick on some things that we learned. I just want to run through those for another draft for us to look at. Just kind of walking through here. One of the biggest issues is whether all these locations should have the traveling to returning from language. I mean, I can understand it with courts and hospitals and a couple others that one could say, hey, I got a summons, I have to go to court, or my leg's bleeding or whatever. But some of these others, it may not make sense. Although I kind of want to also be looking at the fact that, at least with respect to the remedies in 3A, and this is something that Julio just kind of mentioned, the knowing and willingly, that the person violates this knowingly and willingly, that the person would have to know the person's on their way to the court. And I think that one could show them the summons, but it's something, it's a standard that would have to be proved in that kind of case. But I need to look into that a little bit more, but my,
It was knowingly added.
that's been in there. That's been in, that was when we did the court.
This is our first draft,
Yeah, that we haven't touched that, the knowingly enrolled.
came from the Senate. That one.
No, it came from the current law. Current law in the court, that we have the. So I'm also gonna look and try to encourage, finding something, a more better definition of establishment, distributing the essentials of life. And when I looked at that, I thought food bank, but as Tom says, grocery store seems to fit. And I don't think we want to have this that broad. Well, I'm going to ask Rick about that. I'm going to flag that for Rick. I'm also going to flag as far as the definition of place of worship. We had something related to the 501c3 tax code. I am also just going to put in a couple of additional locations that we heard that people encouraged us, so we can take some more testimony on that. That's libraries, DMVs, or maybe state buildings. I don't think we want to put in municipalities. That's up to them. I think those are the things that I have to kind of just to look at for next. Yeah.
I was under the impression when it left the Senate, the agreement was state building was not going to be in this bill. That's what I was told directly.
Yeah, from the Senate.
Okay, so we put it in.
We'll look at it, and take some testimony on it. I think it's easier to take testimony if we actually have this in here, and it depends on where we are. I think that.
I thought we were looking at the Senate bill,
Yeah, this is the Senate bill. Yeah.
but apparently it's not, it's been added.
No, it's not been added. I'm suggesting, given testimony, that for a version that we would look at that.
It says it on that document, doesn't it?
No,
As far as what? No,
Government building?
no, it doesn't have
Oh,
government.
it's at the top and the header?
it might be a header from where they took it out.
No, it doesn't. I don't see government buildings on here. No.
I can see it in the Senate version online.
Is it as introduced?
Yeah.
Or the Senate
No.
as passed the Senate?
Passed,
You're looking at it.
official.
Yeah, no, tell me where you're looking at.
Because the official has the original language too.
Did they change the name of it when they passed it out?
Yeah, that may have
It
been.
says government building, that's 209, bill as introduced and passed by the Senate.
Wouldn't it be in the bill that they changed the name of it?
Let's see. What you would think.
Now it says an act relating to prohibiting civil arrest in sensitive locations.
Yeah, no, I think that's just a description that's in the as introduced version. You're looking at probably the official version of the bill as introduced, right?
Sorry.
Yeah, I see that at the top, court procedure, but that doesn't mean it's in the body of the bill. Because it's not actually in the bill itself. So I'm just suggesting, that these are some of the things that I thought we should look at in the next version. Is there anything else that people would want to look at?
I don't know what folks think about getting a little more specific or clear about the pre-K thing, since we do have so many like different.
Do you have
types
ideas of
locations.
that or?
Well,
that's
I'm
something
just looking at the list.
Licensed paid programs. Because if they're,
I don't know how that changes it. It might, and I just don't
Right.
know. But I'm trying,
or
like, there's they just have a list of public and private pre-K providers list, but interestingly, that's on the from the Agency of Education, but we only say a pre-qualified private kindergarten. I guess that's because the public are in schools and so they're covered, but I'm just trying to figure out if we need to add something specific, like including in-home providers or something, I don't know. So I didn't feel like,
What's that?
20 more things for us to have to remember.
I didn't feel like that
It's
was,
to the point where we list the opposite side.
Yeah, it might be easier.
So, yeah, we can think about that a little bit more or have more testimony on that. But this is just to kind of move this along. I think helping presumably it helps if we take care of that traveling or returning to from most of the locations. Hopefully that helps. And some of these definitions. And we'll see where it goes. Just one other thing, S208, DPS has been working, Ian's kind of been the point person with DPS. And we're gonna have a version that is mostly what we got back from DPS. We have a couple word things that we'll talk about, but I just want to give, we'll make sure we flag that those couple word things that we think are a little bit better. But that we'll look at on Wednesday. So hopefully that one's moving along fairly well. And thank you again to the Department of Public Safety for doing the work on that. But that's it for now. We have one witness after the floor tomorrow, and that is, it's back on the forensic facility. We're adjourned until tomorrow after the floor then.